Good morning, everyone. Today, I'll be presenting on the topic Advise Parents on how the Sexual Offences Against Children Act 2017 protects children from sexual offences. To begin with, I'll discuss the background that led to this introduction, followed by its primary purpose and how its specific provisions protect children from harm. The Sexual Offences Against Children Act 2017, also known as SOACA, was introduced in response to the high rising incidence of child sexual abuse and the limitations of existing laws. High profile cases like Richard Harker's crime, combined with global pressures and advancement in technology, expose the gaps in Malaysia's legal frameworks. Issues like online grooming, child pornography, or also known as child sexual abuse materials, are inadequate victims support demand and urgent attention. The Sexual Offences Against Children Act was introduced with two key goals in mind. So first, to address various forms of sexual exploitations, abuse and grooming of minors. The Act provides a clear definitions, imposes a stricter penalties, and also introduces mechanisms to combat sexual offences effectively to create a safer environment for children, especially by addressing emerging threats like online exploitations. This reflects that Malaysia's commitment on adopting the challenges of the digital age and safeguard children's rights. So ACA is testament to the nation's determinations to protect the most vulnerable members to ensure the future is secured.
Thank you, Jinsan. The offences relating to child pornography. The Sexual Offences Against Children Act 2017 is a very important law that helps to protect children from sexual crimes. It focuses on stopping the creation and sharing of child sexual abuse materials and the involvement of children in these activities. So this law is very crucial for keeping children safe and for making sure that those who exploit them face serious consequences. Part 2 of Section 4 explains that child pornography, in another phrase, such as child sexual abuse material, is anything which includes pictures, videos, written content that shows a child or someone who looks like a child in sexual activities. So this can be anything from sexual acts to showing of private body parts. So it makes it illegal to create or direct child sexual abuse materials. Under Section 5, if someone is caught making or directing such materials, can be punished to up to 30 years in prison or at least 6 strokes. So these penalties are meant to stop people from committing these crimes and to show how serious these offenses are. Under Section 6, also punishes those who plan to create child sexual abuse materials or use children to make it, with a term of imprisonment of not exceeding 10 years. So under Section 7, for example, if someone tricks a child with a fake advertisement to get them to participate in such activities, or offers a child to someone for making child sexual abuse materials, they're breaking the law and may be punished to a term of 20 years with whipping of not less than 5 strokes. But Section 8 and Section 9 targets the sharing and the viewing of such materials. So it is illegal to exchange or to publish or to sell child sexual abusive materials, including selling it to children. So watching it is also a crime. However, the law understands that sometimes people might accidentally come across such materials. So if someone unknowingly receives a child sexual abusive material but deletes it right away, they're not creating a crime. But if they keep watching it or they save it for later, they're breaking a law under Section 10. So this distinction is very important because it acknowledges that people can be exposed to child sexual abuse materials unintentionally, but it still remains its strict penalties for those who deliberately engages with it. So overall, the Sexual Offences Against Children Act 2017 is a very powerful tool in the fight against child exploitation. So it provides clear definitions and strict penalties for those who create, distribute, or view child sexual abusive materials. And it also recognizes the importance of preventing such crimes before they even happen by punishing preparatory actions. So passing it on to my fellow student Kuguletu. Thank you.
Next, I'll be talking about offenses relating to child grooming. So the widespread use of the internet today means that simply being at home may no longer offer complete protection for children from the risks of crime. Even within the safety of their own homes, children can become targets. A growing trend is for offenders to create fake identities online to gain a child's trust, often by posing as someone of a similar age. This allows them to groom the child for sexual activities or engage in inappropriate communication, which could lead to further crimes like sex extortion or blackmail involving explicit content. Section 12 and 13 provide protection for cases relating to child grooming, and under Section 12, communication by any person with the intention to facilitate the offenses listed in this section or any offense specified in the schedule will be criminalized. And any person who has committed these offenses on a child is criminalized under this act with a term not exceeding 5 years and shall be liable to whipping. So once the victim begins to gain trust in the suspect will start manipulating the situation to achieve their goals. They may engage in grooming behavior to obtain sexual material, gradually asking for explicit photos or other compromising content. The next thing that may happen is traveling to meet with the child or meeting the child to facilitate the acts mentioned under Section 12. Protection for this is provided for under Section 13, and any person who does so will be punished with imprisonment for a term not exceeding 10 years, as well as whipping. Next, I'll be looking at offenses relating to sexual assault. This act broadens the scope of sexual offenses involving children to not only include physical abuse but also non-contact crimes like online grooming and the sharing of child exploitation materials. This ensures that offenders are held accountable for a wider range of harmful behaviors. So any parents with a child who has been a victim of the offenses relating to sexual assault can rely on Section 14 of this act. Therefore, any person who conducts physical sexual assault on a child shall be punished with imprisonment for a term not exceeding 10 years. So a child can also be sexually assaulted without any physical contact, and the Act provides protection for this under Section 15, and any person who commits an offense under this section will be liable to imprisonment for a term not exceeding 10 years or to a fine not exceeding 20,000 ringgit or to both. The Act includes provisions that criminalize grooming behavior, such as engaging in communication or forming relationships with the intent to sexually exploit or abuse a child. This includes online grooming, where an adult will use the internet to attempt to manipulate, deceive, or coerce a child into sexual activity. So the Act also generally sets a clear age of consent below which children cannot legally agree to any form of sexual activity. In many instances, even if a child appears to have consented, it may not be recognized under the law. If the child is below a certain age, the law often criminalizes adults who exploit children for sexual purposes, even if the child does not resist. So this 2017 Act typically increases penalties for those convicted of sexual offenses against children, sending a strong societal message and holding offenders accountable with harsher punishments. So this act provides protection to children who have been victims of child grooming and sexual assault by including provisions covering both direct and indirect offenses, such as the grooming of children for sexual exploitation or the possession and distribution of child sexual abuse material. That's all from me. Thank you. I'll now pass on to the next person.
Thank you, Bubu. I'll now be moving on to Section 16 of the Act. Under Section 16, Subsection 1 of the Sexual Offences Act 2017, anyone who commits an offence against a child will be subject to this clause. The type of offence can include those specified in the Act or in a schedule related to the Act. A person who violates this Act or any of the schedule's listed offences against a minor while being in a relationship of trust with the child will not only face the penalty for the offence, but is also subject to imprisonment for a term not exceeding 5 years, as well as 2 strokes of the cane. The intention of Parliament in enacting Section 16, subsection 1 is to send a message to society at large that this type of crime is not to be taken lightly, as it will leave a very deep impact on the victim, as seen in the case of Noor Asmi bin Ibrahim against the public prosecutor. When the courts assess the severity of the punishment, they look at whether a relationship of trust has arisen between the offender and the child. An individual is deemed to be in a relationship of trust with a child if the child is under his care, supervision, or authority, which may include parents, guardians, or a person related by full blood, half blood, marriage, or adoption. Secondly, the individual may be someone that cares for one or more children for valuable consideration for any period of time. Besides, it can be a teacher, lecturer, warden in a kindergarten school, public or private university. Thirdly, it can be any individual that provides healthcare services in a government or public healthcare facility that is defined under Section 2 of the Private Healthcare Facilities and Services Act 1998. The individual can also be a coach or public servant that is doing his duty under written law regarding the child, regardless of his rank. Part 6 of the Act is regarding the capacity and evidence of a child witness. It is generally assumed that a child is competent in giving evidence in any proceedings against any person tied to any offense under this Act or any offense that has been specified in the schedule where the victim is a child, regardless of what any other written law may say under Section 17. Section 18 of the Act provides that the court may convict an individual of any crime under this Act or any crime that is listed in the schedule in which the victim is a minor based on uncorroborated evidence of a minor, whether provided under oath or in any other way, notwithstanding anything in contrary with any other written law. I'll now pass to Ziliang.
Thank you, Shen Kai, for the wonderful explanation. I'm Ziliang, and I'll be talking about the miscellaneous part. Alright, to sum it all up, the most important thing in the miscellaneous part is where you should not withhold information of the commission or an intention to commit an offense under this act where the victim is a child, which is Section 19, or you will be liable for a fine not exceeding 5,000 ringgit. And then you are not able to use the presumption of age of a child as a defense if you commit an offense under this act, unless that you have taken all the reasonable steps to ensure the age of the child, like birth certificate, everything, unless the birth certificate was a forgery, which you did not know at the time of committing the offense. Next up is abetment, which is Section 21. This section is talking about if you encourage or assist or be a part of accessory to this offense, you will be punished with the punishment provided for the offense that was committed. The next one is Section 22. Agent provocateur, meaning that someone who is sent to commit, abet, or assist the person in committing the offense in order to gain evidence to hold him for liable. It shall not be unworthy or illegal, or the agent or provocateur should not be arrested, as it is doing this to get a confession out of the accused who committed this. Moving on is the offense by corporate body, Section 23, where the recent GIFB case would be the best example, where the CEO knew of what was going on, the sexual abuse, the assault, and he is now charged with it as he did not give information about it. So he shall be liable for Section 19 and Section 21 abetment also. This is also be the voice of the child, where you should not turn a blind eye to all these things. Next up is Section 24, which is like you will not be able to get bail or anything, like even if you have good conduct, if you convicted the offense and you're over the age of 18. And for 25 is that any male who is more than 50 years old of age, you will still be liable for whipping no matter your age if you commit any offense under this act. And 26 is if you commit any offense under this act, you will be sent for counseling during your detention period, where if you're arrested, they will counsel you in hopes of you able to change and be a better person when you're released. And Section 27 is police supervision. This one has a maximum of 3 years and minimum of 1 year. And if you're in prison, if your sentence is 10 years in the prison, it will not be taken into account, and when you're released, you'll still be under police supervision 1 year or to the maximum of 3 years. The final one is Section 28 schedule, where the Minister of Law may amend the schedule of this act upon consultation with the public prosecutor, such as exclude or include any offense under the written law, but they will have to publish this on the Gazette of talking about why they did this and what's their purposes. That's all for my part, and I hope that this knowledge is helpful to all of you who are watching. I pass it on to Jin Xiang, who is doing the conclusion. Thank you.
In conclusion, the Sexual Offences Against Children Act 2017 is a critical step in safeguarding children from sexual exploitations. Its clear definitions and stricter penalties, alongside with its focus on the modern threats like online grooming and child pornography, also known as child sexual abuse materials, demonstrates Malaysia's commitment in protecting its most vulnerables. Provisions with the Act ensures not just only that the punishment of the offenders, but also ensures that the dignity to be returned to support the victims. However, as as with any laws, SOCA must involve itself to address new challenges, just like how the outdated penal code eventually fell short in protecting children. The future advancement in technology and shifts in criminal behavior will demand the updates to the Act. Continuous adoption and vigilance are the key to ensure the safety and well-being of children in an ever-changing world. These are all our references, and thank you.